and welcome to the future. I'm Pauline Ken. Now let's talk company directors. Now company directors are the authorized officers of a company, and they together form the board of directors. Now, beside the historic requirements of the board of directors, such as making strategic and operational decisions of the company, contracting on behalf of the company, and basically managing the daily activities of the company, the Companies Act of 2015 also recognizes certain express rights and duties of directors under Chapter 9. Now, Article 141 of the Companies Act of 2015 recognizes certain rights that accrue to directors. The first one is the right to not have their residential addresses and physical addresses disclosed to other parties. The second right that is provided for expressly under the Companies Act and under Article 141 is the right to challenge any removal of a director from office. Now, this therefore means that the annual general meeting cannot meet and pass a resolution to remove a director from office. This is because under Article 139 of the Constitution, there has to be a pre-special notice before that particular ordinary resolution is passed to remove a director from office. Now, the final right that accrues to directors is not to have their physical address disclosed to other parties and which address they have included in the forms for registration of the company. Now, there are other implied rights of directors under the Companies Act of 2015. And these implied rights include, first, the right to security of tenure. Now, this basically means that while the previous Companies Act did not recognize, or rather only recognized directors to act as so until the age of 70 years, the current Companies Act does not, or rather scraps off this age requirement. And this therefore means that directors can hold office well into continuity and perpetuity till they are too old to hold office anymore without an age requirement. Now, secondly, there are certain rights that directors, or rather there are certain obligations under the Companies Act that accrue to directors. And these obligations must be fulfilled by directors in entirety. These begin from Article 142 of the Companies Act, and they include first the right to act within powers. Now, this right basically means that company directors cannot act ultra vires, outside their powers. The powers of company directors derive from the Articles of Association and also derive from the constitutive documents of the company. These constitutive documents include the contracts that the company has entered into, such as the shareholders agreement and the joint venture agreements. Now, the second duty of directors under the Companies Act and under Article 143 of the Companies Act of 2015 is the right to promote the success of the company. The second duty and obligation of directors under Article 142 of the Companies Act is the duty to act in a manner that promotes the success of the company. Now, this therefore requires a deliberate effort on the part of directors to ensure that whatever contracts they represent the company in are contracts that are ultimately geared towards the profit of the company and the success of the company. The third duty of directors under the Act is the duty to act independently, and this includes contracting an independent advisor on certain issues that require expertise. The fourth duty is the duty to act with due care, skill, and negligence required of a person in the capacity of a director of a company. This therefore means that there is no room for negligence, there is no room for breach of contract, and there is no room to act in a manner that is lax, in a manner that does not portray a person who is duly appointed to be a director of a company. There are other duties that are basically implied by the Companies Act and which directors must also fulfill. Now, the duties that have been discussed previously are basically described as positive duties. These are duties that directors must do. There are other negative duties under the Act, basically duties that directors must not do. And these include, for example, obtaining loans on behalf of the company without obtaining consent from the members. The second negative duty of directors is to not accept favors from third party in relation to their duty as directors. The third duty of directors that is a negative duty, and what they must not do is to allot shares without the consent of the members. Well, finally, we need to know what are the duties of directors in the instance of liquidation of the company. Now, when a statutory liquidator has been appointed in respect of a particular company, of course, liquidation being the first step, the other option that a company has when it is under distress, is to voluntarily arrange for a scheme of arrangement. Now, once a liquidator has been appointed in respect of a company, the duties of directors first include to resign and to address the resignation letter to the statutory liquidator. The second duty the directors have, and which is a primary duty and a major duty, is to cooperate fully with the liquidator. Now, cooperation means the following things. First, the director has to be present at all times. This is not the time for directors to take leave and go for further studies in a different country. You have to stay within the premises and the registered offices of your company to cooperate with the liquidator. The second duty that requires full cooperation of directors is to produce information where required by the statutory liquidator. This therefore means that if the liquidator wants to know when the company was incorporated, when a certain contract was entered into, all this information should be provided to the liquidator. Finally, the director has to provide and produce documents as and when demanded by the liquidator. Now, the key word here is upon demand. This therefore means that a director of a company cannot put all the documents with respect to the company in a box and dump them at the liquidator's doorstep. You have to produce the documents only upon demand. When the liquidator wants the certificate of incorporation, you avail it. When they want the joint venture agreement as concerns a particular date in time, you produce it as and when demanded. Well, finally, the duties of the directors overall include cooperation with the liquidator and avoiding to hold meetings that beat the purpose of the statutory liquidator and that frustrate the efforts of the liquidator in putting the company under statutory liquidation. Well, thanks for watching. To get these and more videos, please log on to your Gmail account and subscribe to my YouTube channel, The Future, and find out whether or not you are part of the future of law.